Armenia delivers such an effective remedy? No, it does not. In accordance to the jurisdiction of this court, concerning Article 13, this redress has to provide precisely determined and practically enforceable redress that might allow the applicants to return to the land plots, and it must have a competent authority to be addressed to. The Constitution does guarantee the right to property and the right to respect for private and family life, but it contains neither a provision for the enforcement of applicant claims nor determines a competent authority. Such a constitutional regulation may never substitute a system of procedural provisions and regulatory competences aimed at realizing the effective implementation of rights. Any other assumption or arguing would completely be against the foundations of the rule of law, in particular because it would not ensure legal forcibility and it would jeopardize legal certainty. Does the Land Code 91 of the respondent represent an effective remedy, as the respondent claims? No, it does not. Why? As Article 119 of the Armenian Code, Land Code 2001, implies that after its entry into force, the Land Code of 1991 expires. That's why the Land Code 91 has no more effect in our case. Next question. Does the Land Code 2001 represent an effective remedy? No, it does not. Why? Please read carefully Article 4, Para 3 of this Land Code, and you will find there, repeating, by the way, the Article 31 of the Constitution, and I may quote it because it has so strongly been claimed by the respondent. This Article 4 says, foreign residents and non-citizens of the Republic of Armenia cannot obtain property rights on land. They can only be land users. From that follows that Azerbaijani citizens are excluded by law to be or to become landowners. Together with Article 1 of the same Land Code, which states that other laws and statutory legal acts on regulation of land relations must be, in any case, with strict correspondence to the Land Code, makes clear that no other laws of the Republic of Armenia could substitute or could give more restitution ground than the clauses of the Land Code. We have a very clear regulation in Article 117, Para 2 of the Code, which says that land relations arising before the implementation of this Code will be regulated after the rules of this Code. That means that there is no question about it, that the Land Code 2001 is governing our questions of the IDPs, of the claimants. Does the Land Code of the so-called of NKR provide effective remedy? No, it does not. It contains only. It does not contain provisions for compensations in the case of property losses or restoration of the loss of property rights. I conclude, neither the rules in the Republic of Armenia nor the rules in Nagorno-Karabakh, so-called Nagorno-Karabakh, gives remedy. Speaking about the cases which Mr. Robertson has tried to elaborate, we do not know one single case which has been presented by the respondent in which Azerbaijan IDPs, not being of Armenian ethnic origin, would have had redress under Armenian or NKR law. The cases which are in our files at least have no whatever success concerning effective remedy, and they did not have any chance of justice. Does the human rights defender...
Mr. Lansky, may I ask you to conclude, please? Your time.
Yes, Mr. President. Also, the rules of the human rights defender do not give any chance to order any measures or impose any sanctions. That's why also those rules have no chance of success under effective remedy criteria. Thank you, Mr. President.
Thank you, Mr. Lansky. I turn now to the judges if there are questions. Judge Pesquera, please.
Yeah, thank you, Mr. President. Only one question, an affirmation that somehow has struck me, to both parties. I understand, we know that Azerbaijan is a country which is a signatory of the European Convention on Human Rights. It's bound by it. Armenia is also a signatory of the European Convention. Now, looking at Nagorno-Karabakh, if Nagorno-Karabakh were a separate, independent state, not being a signatory of the European Convention, would be the European Convention applicable, will be enforced, will be the rights recognized by the European Convention enforced in the territory of Nagorno-Karabakh? In this case, if it were not under bound by the Convention, what would be the relevance of Article 35 of the Convention for the territory of Nagorno-Karabakh for this case? Thank you.
Thank you, Judge Lopez Guerra. Judge Ziemele, please.
Thank you, Mr. President. My first question is indeed on jurisdiction, since in the pleadings just now we heard all three parties indeed discussing at length this issue. And I would really appreciate if the applicants, the respondent government and the third party, if you wish so, clarified your point. And the point you were making is the following. You were drawing comparison with the ICJ's judgment in the Nicaragua case, followed up by, indeed, as mentioned, by the genocide case. And you were suggesting that, in fact, this court has taken a different approach as compared to the one taken by the ICJ in the Nicaragua case. I would be much obliged if you gave an indication, one or two elements, with reference to Ilashku or Loizido cases. Where do you see exactly that this court has, in fact, departed from the ICJ's approach as concerns test of responsibility? And secondly, I have a small question for the applicants. If you could very briefly answer, the question goes to Article 1 of Protocol 1. Is your submission, in fact, that there is a specific and identifiable administrative, executive, or legislative act or action attributable to the respondent government which has prevented the applicants that you represent from accessing their houses, which are these acts or actions, or in fact your submission is, under Article 1 of Protocol 1, that the respondent state is under a positive obligation to adopt policies, legislation, etc., that would enable the applicants to access their houses. Thank you, Mr. President.
Thank you. Judge Williger.
Thank you, President. I have a question to the respondent government, something that the learned representative said which I didn't understand, and maybe I'm overlooking something. I would be glad for clarification. The respondent government said that the applicants did not exhaust domestic remedies available to them in the Nagorno-Karabakh Republic and in Armenia. Now, the applicants had their property in Lachin, occupied by the Nagorno-Karabakh Republic. That is undisputed. So I can understand if you are claiming that the applicants should have gone before the courts of Nagorno-Karabakh. But you also said that they should have gone before the Armenian courts. And I just have one quote here, which the learned representative said, lawyers and judges in Armenia are waiting to process these claims, end of quote. Here I am confused, puzzled. What do Armenian courts have to do with the Lachin area occupied by Nagorno-Karabakh Republic, where the applicants had their property? How could Armenian courts have provided legal redress to the applicants? Maybe I have overlooked something, and I would be grateful if you could clarify. Thank you, President.
Thank you, Judge Williger. Judge Paulo Pinto de Albuquerque, please.
Thank you, President. 3 questions, all addressed to the respondent government and all regarding non-exhaustion of domestic remedies. First, can the government solemnly guarantee to this court that the statement of the Lachin judge with regard to the admissibility of claims of property by people of Azeri and Kurdish origin are still valid today? Second, 2 cases were referred by the respondent government of restoration of property to Azerbaijani IDPs, and I went through the whole file and I cannot remember to have read any reference to these 2 cases. I would be grateful for clarification with regard to the date when these judgments were delivered, by which court, and if these 2 judgments are yes or no final. Third question. Is there any legal provision in the NKR prohibiting or expropriating ownership of land or other property by people of Azeri or Kurdish origin? We know what the so-called constitution of the Nagorno-Karabakh Republic says, but is there any additional legislation which directly prohibits or indirectly prohibits or expropriates ownership of land or other property of IDPs from Azeri or Kurdish origin? Thank you.
Thank you, Judge Pinto de Albuquerque. Judge Gülümyan.
Thank you, President. I have questions for both parties. First, 3 questions for the applicant. Is it the applicant's case that the highly respected judges, ministers, and lawyers of Armenia and Nagorno-Karabakh are lying in their witness statements? If so, will you please point out the lies or false statements that you allege? This is the first question. And second question, as you mentioned, the applicant's lawyers admit that they have no experience with Armenian or Nagorno-Karabakh law. Why didn't the applicants seek help from lawyers with such an experience? And my third question, as we know, your government has adopted so-called blacklist of foreigners who visited NKR. My question would be, could their own citizens freely travel to NKR without fear that they will be punished by their own government? We had the case before this court, Einullah Fatulayev, in which we know that the applicant was punished for his visits to Nagorno-Karabakh and for his articles concerning Nagorno-Karabakh. Now my questions to the government. Our first question concerns the passports. In which cases a resident of, in which concrete